So, presentation this morning. Those are the speakers. You'll see them all, so we'll move on from that. The agenda today, we're just going to talk about mainly, I guess, two big issues in relation to the Employment Rights Bill, the things that are happening most immediately, and then the major changes, and there have been some major changes this week. I think changes that are going to be a bit more useful for businesses. As part of that, I'm going to be talking about some New Year's resolutions for employers, and then there'll be a discussion point towards the end about AI, which everybody likes to talk about, and I like to talk to you about with anyone that I meet. And so, because there's plenty of content, I'll move things on and hand you over to Jake and Tyler.
So good morning, everyone. As Kevin mentioned, we're going to be discussing the Employment Rights Bill today. As you all know, the government are intending on implementing the bill in stages, so we're going to be discussing the more immediate changes and what your businesses can be doing to prepare in the new year. So the first topic I want to discuss today is unfair dismissal. As I'm sure you all know, the government have been committed to implementing a day one right for employees to not be unfairly dismissed, and understandably this has caused a lot of concern for employers. Not least because of the complexity and uncertainty surrounding that initial period of employment. However, late last week, and after plenty of back and forth with the House of Lords, the government have now dropped the day one right and are intending on reducing the current 2-year qualifying period down to 6 months. So when the bill comes into force, you need to think about what does this mean for your business. Well, immediately, the obvious point to note is pivoting from that day one right to the 6-month qualifying period. That will give you more flexibility than you initially anticipated to assess new hires and address early performance concerns. However, because they are, instead of the day one rights, because they're not introducing that and are instead keeping the qualifying period, it's anticipated that this will now, the measures around unfair dismissal will now be implemented as early as next year, rather than 2027 as was initially anticipated. So it's really important you start thinking about these changes now and how you can prepare your business for those. So for example, start reviewing your recruitment process as early as next year. Things like is it suitable to add an additional interview in there or an additional assessment to really make sure you're checking candidates for those competencies you're really looking for to make sure you do get the right hire. As well, you want to start thinking about how you can manage the employment relationship in those early stages. So, for example, I know a lot of businesses have a standard 6-month probationary period, which is fine, but you might want to think about having those discussions around the 3-month mark, set those expectations and those potential improvements before the employee gets to that 6-month protection period. Interestingly as well, the government have announced more recent changes to unfair dismissal relating to the cap for a successful unfair dismissal claim. As you can see from the slides there, the cap is currently set at the lower of 1 year salary or £118,233. It's currently not confirmed, and it's slightly uncertain which part of the cap is being lifted or removed. However, what is certain is if you get a dismissal wrong, it is certain that you will be facing more costs if that process is wrong. So when these changes are implemented, it will be important to get that dismissal process down to a T. And of course, if you do find yourselves in a situation where you're looking to dismiss an employee, whether that's now obviously or when these changes come in, when there's a little bit more risk involved in terms of liability, we strongly recommend you obviously come to us and we can assist you with that. So bringing these changes into the bigger picture then, because the government have dropped the day one right, it's looking more likely that the bill is back on track to be implemented as initially was intended when the government published their roadmap earlier this year. So I'll now pass you on to Jake, who will discuss some of the more immediate changes when the bill comes into force. So over to Jake.
Hi, so when the bill comes into force, there'll be some immediate changes around trade union rights. I'm not going to go into those because you won't thank me for that, but generally, as you might expect, those trade union rights will be strengthened, and also in terms of strike action, the procedures around that will be relaxed slightly. So when the bill receives royal assent, so when it's passed, the bill will repeat in full immediately the Strikes Minimum Service Levels Act from 2023, which was legislation from a few years ago, which was some would say was deemed to be sort of anti-trade union. So that dealt with a lot of things in terms of having minimum service levels, 50% turnout for strike action. So that will be overturned immediately. And then within 2 months of the bill coming into force, there'll be some other changes, basically trying to simplify the process and trying to relax measures around strike action. So as an example, the time needed to give, or the notice required for industrial action will be reduced from 14 days to 10 days. So I'm going to talk more about the changes in April. So the first one you can see on the slides is the increased protection, whistleblowing protection in relation to sexual harassment. So the Employment Rights Bill more generally has quite a few provisions around sexual harassment, about stamping it out, taking a tougher stance in the workplace. This one is the first of those measures that's going to be introduced in April. So currently there are protections for workers who make what we call a protected disclosure, so blowing a whistle. So that's when somebody reports wrongdoing by the company that they reasonably believe is in the public interest. So if someone makes a disclosure in that way, then they have the right not to be dismissed for doing that, and also the right not to suffer a detriment, so for example being excluded or treated unfairly. So for a disclosure at the moment to qualify for whistleblowing protection, it must fall into a specific list of topics. So by way of example, those could be disclosures about a criminal offence, disclosures about a company's failure to follow a legal obligation, or also where there's been or likely to be a miscarriage of justice. So what this bill does is add specifically sexual harassment to that list of topics. So employees can already blow the whistle around sexual harassment, because in a lot of cases where somebody reports concerns around sexual harassment, it probably already falls into one of the existing categories. So if somebody's saying that they've got concerns about widespread harassment in their office, that's likely to amount to a failure by the company to follow one of their legal obligations. The change doesn't mean that any complaint or concern around sexual harassment will automatically be whistleblowing. So they'd still have, for example, the individual would still have to show that they've directed that disclosure to the right person. So, for example, who's listed in your whistleblowing policies. But also they'd have to show that when they made that disclosure, that they made it in the public interest. But I guess the intention of this generally is the government hopes that it will encourage people to come forward where they've experienced or witnessed harassment. So that's in line with other provisions that the bill will introduce at a later date. So whilst this is the first one, the bill is going to introduce or reintroduce third-party liability for harassment, including sexual harassment, as well as some of you will remember last year there was a new duty that came into force that employers must take reasonable steps to prevent sexual harassment in the workplace. That's going to be strengthened to all reasonable steps. So this is the first of those measures around sexual harassment that will come into force in April. So in terms of preparing your business, make sure you've got your policies and procedures up to date around sexual harassment. So in terms of what that policy might look like, make sure it says, who to raise complaints to, who, investigation, what that might look like, timeframes, but also given this new whistleblowing protection, if you haven't already, add some words in around sort of reassuring staff that if they do come forward with concerns, that they'll be protected from any sort of retaliation or protected from suffering a detriment, even where their genuine concerns may turn out to be mistaken. You'll also want to make sure you have in place a sexual harassment risk assessment. That's probably the first thing to do, and we can provide that if you don't already have one. Also train your staff, particularly management, those in leadership positions, because they're the ones who will have to react, deal with disclosures. As a team, we've been rolling out sexual harassment training during the last 12 months to various clients across different sectors, so if that's something you think would benefit you, let us know at the end. It's also worth remembering too that if you do use settlement agreements for various situations, that an employee cannot validly waive their right to blow the whistle under a settlement agreement. So it might be from April that issues or concerns around sexual harassment will no longer be covered by the confidentiality provisions. Next slide, please. So talk next about the changes to the collective redundancy award. So The current position is that where an employer is proposing to make 20 or more redundancies in one establishment within a period of 90 days, then it must go through the collective consultation process. So many of you will probably know a lot about that. They have to elect representatives, consult with them, consult with individuals. But if a company breaches that in any way, does it wrong, then amongst other things, an employee can claim for what we call the protective award of up to 90 days actual pay. So under the bill, that's going to double. So it's going to jump from 90 days to 180 days for actual pay. In terms of preparing, again, I guess the obvious point to make is if you are considering large-scale redundancies, then make sure you comply with the various parts of collective consultation, and again, we can assist with that. But it's also worth bearing in mind that if you are proposing or thinking about large-scale redundancies and perhaps want to go down voluntary redundancy as a way, be that you just be aware of this award, because that might feed into or steer what sort of payments you look to offer and expectations around negotiations with staff. It's not on the slides, but I want to talk as well about the establishment of the Fair Work Agency. So again, this is in April next year. So at the moment, most employment rights are enforced by an employee by bringing a claim at the tribunal. There are some rights that can be enforced by the state on behalf of individuals, but not many. But from April, this will change. So the government's going to set up this new public authority called the Fair Work Agency. I guess the idea is to bring existing state enforcement functions under one roof to help streamline the process, and it'll hopefully be a place where, I guess, employees can go to one place where they need assistance that isn't the tribunal. I suspect part of it is trying to alleviate some of the pressures that the tribunal system's under. At the moment, when a claimant brings a claim, it can be 2 years before the hearing's listed. So hopefully this will try and alleviate some of those pressures. In terms of what they might enforce, this is still to be finalised. We're still waiting for the full details. But it includes things like the national minimum wage, holiday pay and sick pay. And in terms of what sort of action they take, again, we're still waiting for the full details. But we're told so far that they'll have powers to investigate and take enforcement action. That might include actually going to someone's workplace, inspecting, requesting the employer to provide evidence of compliance of whatever law has been alleged to have breached. It can also include issuing notices of underpayment and requesting back payment, for example, for holiday pay. And also, they've said as well that the agency might be able to bring proceedings on behalf of employees. So in terms of next steps, it's unlikely that this new agency will become fully operational for quite some time, but it doesn't mean it's not a good idea to get your house in order more generally to get ahead of it. So particularly around holiday pay. So holiday pay is something that can be quite tricky, especially for those of you in sort of retail and leisure sector where there's a lot of casual workers, irregular hours workers. It can be troublesome. So now that they're introducing this agency that can bring enforcement action for issues of holiday pay, it's a good idea to have that on your radar. Also, it remains to be seen how it's funded, this new agency. So there are other similar bodies that exist at the moment, like the Equality and Human Rights Commission. That one in particular is quite limited in resources, so in terms of their enforcement action, they tend to target sort of prolific or larger businesses. It might be the same case with this new agency if it's underfunded, or if it receives more funding, there's more risk that that agency will go after smaller businesses and have more appetite to do so. So I'll hand it back to you for the...
Great. So, unlike with unfair dismissal, the government are still committed to bolstering workers' rights from day one. And one way they're looking to do this from April next year is kind of overhauling the regulations around statutory sick pay. So currently, the qualifying conditions to receive SSP kind of boil down to earning an average weekly wage of £125. And also, SSP becomes payable from the 4th day of illness. Well, from April, the government are, radically changing that. So SSP will start becoming payable from the 1st day of illness. And they're also looking to remove the lower earnings threshold as well. So an employee won't have to earn a certain amount to be eligible for SSP. Now, the impacts this is going to have on businesses, some of them are blaringly obvious. For example, higher sick pay costs. but also increase short-term absences as well. So if sick pay is becoming payable from that first day, there's no longer that deterrent for employees to kind of work through feeling a little bit rough, because they're going to be getting paid from that first day. So you can expect to see, in some cases, increase in short-term absences as well. But also, this is going to capture some further workers who might not necessarily be eligible for 0 hours now. So for SSP now, sorry. So for example, 0 hours workers. Okay, if you've got a 0 hours worker doing 1 shift a week, they might not necessarily earn the £125 per week. However, when this comes into force, obviously they will. Doesn't matter what they earn, they'll be eligible for SSP. So that's something to think about, like Jake said, for those, especially in the hospitality and leisure sectors as well. But in terms of getting ahead of this and things to be thinking about then, like Jake said on a couple of points here, reviewing your policies, okay, so are these new qualifying periods, your policies need to reflect those, obviously as well, removal of the earnings threshold. Your policies are going to have to obviously comply with best practice from April, so there's no harm in starting thinking about getting that in motion now. As well, contractual provisions surrounding sick pay, statutory sick pay. Obviously, some contracts will need to be updated. That's for existing employees, and then going forward as well, template contracts of employment for any new hires from April 2. Again, something we can obviously help with. But more practically as well, so managers, team managers, they're going to be obviously facing these increased short-term absences. So you might want to think about delivering training to these managers on how they can deal with these short-term absences. So keeping in touch with these employees if they need to, or reviewing that and keeping track of when employees are possibly taking regular absences. But also for those employees who are still coming into work as well. So obviously they're going to be infected by their certain colleagues taking short-term absences. So training managers on how to kind of really allocate work and regulate people's workflow is going to be really important too. Other day one rights relating to paternity leave and unpaid parental leave. So again, you can see from the slides here the current position. Paternity leave requires 26 weeks of service, usually measured 15 weeks before the expected week of birth. And also unpaid parental leave currently requires 1 year service. Okay, so as I mentioned, these qualifying periods are going to be dropping drastically to first day of employment. So as soon as you employ someone, they're entitled to these types of family leave. Again, getting ahead of this, it's just similar to SSP policies. They're going to have to reflect these current qualifying periods. Practically as well, systems, are your HR systems, are your payroll systems kind of well equipped to deal with the fact that more employees are entitled to extra leave? But also as well, for those employers that pay enhanced paternity pay, for example, or give employees paid leave, is your policy going to have to be amended to reflect that when an employee is capable of qualifying for this contractual entitlement rather than just a statutory minimum for paternity leave? Does your business pay for parental leave, like I say? So these are things to be thinking about as well, and whether you kind of want to have these in place from day one as well. But whilst you're reviewing those policies, in particular on paternity leave as well, you're going to want to think about how that fits in with your maternity leave policies. Obviously, you don't want to be seen as favouring one category of employee, like mothers more than fathers. That obviously comes with inherent risks as well, discrimination, etc. So it'll be really important to make sure that your family leave policies are in line. Again, policy reviews, policy amendments is something we offer. So again, if you want to come to us for any assistance with that, we'd strongly encourage you to do so. So they're the April changes discussed by Jake and myself. Jake's now going to just run through some of the consultations that the government are planning over the coming months.
Yeah, I just wanted to briefly say, so on this screen there you've got some consultations that are ongoing, some that are live in the next few months over this winter. So I think sometimes a consultation can feel a bit like a tick box exercise, but actually it can be quite a useful way for a business to voice their concerns based on what they know on the ground. So as an example, last week, as Tyler mentioned, we saw the government sort of change course with respect to day one unfair dismissal rights. That was largely to do with business pressure, which was with them engaging via consultations like these. So if you do have any sort of genuine concerns around any aspect of the Employment Rights Bill, a lot of them are subject to consultation. So I do encourage you to seek those out and to sort of voice your concerns. I know, for example, I've had clients in the leisure sector talk in particular around their concerns about the changes to 0 hours, to compensation for cancellation of shifts. So that's one example of what will be consulted about. So yeah, just a general point. If you do have concerns, use your voice and engage via these consultations. So I think that's it from us.